May I please?
Yes.
Division against Melody. Order detail. 19/4/2018।
फ्रॉम द डेट ऑफ जजमेंट आपको दिया है, फिर भी आप नहीं दे रहे।
जी,
फ्रॉम द डेट ऑफ जजमेंट दिया है ना,
इसमें
इसको तो देना चाहिए था फ्रॉम द डेट ऑफ एप्लीकेशन
यस मिलर्ड
व्यू ऑफ द ऑनरेबल सुप्रीम कोर्ट जजमेंट। दिस शुड हैव बीन अलाउड फ्रॉम द डेट ऑफ एप्लीकेशन। देखे हैं रिसेंट
एक बार
जजमेंट।
इसको नोटिस करके बुला लिया जाता है,
क्यों बुला लें?
उसके बाद दें।
आप पहले ये बताइए कि आप इनको दे क्या रहे हैं जो बुला लें। ये आएंगी कोर्ट में, फिर वकील रखेंगी, कहां से रखेंगे वकील? जिस
उसका एक्सपेंस देंगे ये
उसका एक्सपेंस ही देंगे।
जी।
आप ये बता दीजिए मुझे कि आप दे क्या रहे हैं इनको। 4 साल से ऊपर तो हो गया इस जजमेंट का, आप क्या दे रहे हैं अभी बताइए।
प्रेजेंट स्टेटस नहीं बता पाएंगे।
नहीं, आप कुछ तो बताएंगे ना कि आपने क्या दिया है इनको। आपने इनको कुछ दिया भी है या नहीं दिया है?
अभी कांटेक्ट नहीं हो पाया मेरा।
सब लोगों का यही आंसर आ रहा है, जब भी एक सवाल पूछते हैं कि आप क्या दे रहे हैं, अभी कांटेक्ट नहीं हो पा रहा।
इसमें नोटिस करके बुला लिया जाता।
किसको?
कंप्लेंट ओपी नंबर 2 को।
आप समझ रहे हैं, एक व्यक्ति को जब नोटिस मिलेगा, इस महिला को जब नोटिस मिलेगा, फिर उसके बाद ये क्या होगा उनका? जब आप ही को क्लाइंट से नहीं कांटेक्ट हो रहा है तो इसका खर्चा आप क्या दिलाइएगा? चलिए मेरिट पर बात कर दीजिए, आप अपना काम कर लीजिए, बाकी काम हम कर देते हैं। दिख रहा है क्या है मटेरियल?
4000 पर मंथ
तब
अलाउ किया गया।
बोलिए ना, क्या पॉइंट है आपके पास?
ये हम पैराग्राफ 8 में लिखे हुए हैं दैट इट इज मोस्ट हम्बली स्टेटेड दैट ओपी नंबर 2 इज नॉट लीगली वेडेड वाइफ of the petitioner because her nikah performed forcibly and this fact has not been established by the OP number 2 before the learned family court.
कोर्ट बिलो का देखिए जो डिस्कशन है उसमें, no family member or relatives have been examined on behalf of the OP in support of his case. On the other hand, the petitioner, her parents and other witnesses have been examined on her behalf. They have fully supported the case of the petitioner. The opposite party stated that himself stated that his marriage was solemnized with the petitioner on the conspiracy of parents of the petitioner. बढ़िया है, जितने लोगों की शादी होती है वो कुछ दिनों के बाद कह दें कि ये सब दोनों के माँ बाप मिलकर के कॉन्स्पिरेसी करके शादी करा दिए, इसलिए ये शादी नहीं माना जाएगा। अच्छा बहस किया है आपने कोर्ट बिलो में।
लैंडलेस पर्सन है इस पे।
ठीक है, एनीवे नो केस इज मेड आउट फॉर इंटरफेरेंस। लिखिए, हर्ड लैंड काउंसिल फॉर द पिटिशनर। Petitioner is aggrieved by and dissatisfied with the judgment dated so and so, para 1. By the impugned judgment, the learned court below has directed the petitioner to pay a sum of rupees 4,000 per month towards maintenance allowance to his wife from the date of the order, from the date of the judgment. That date of the judgment, that is 19/4/2018. 19 है ना, 18 है,
19/4/2018
full stop. That counsel for the petitioner has assailed the impugned judgment on the solitary ground that in the learned court below a specific plea was taken on behalf of the petitioner that the opposite party number 2 before this court is not his wife. Full stop. Land Council submits that since the petitioner has denied the marriage with the OP number 2, the learned principal judge family court should have considered his submission. Full stop. Next, this court has perused the impugned judgment. It appears that on behalf of the applicant wife, who is OP number 2 before this court, 6 witnesses were examined, and all of them have consistently stated that the marriage between the petitioner and OP number 2 was solemnized on 29/3/2016 according to Muslim rites and customs, and the OP number 2 had gone to her matrimonial house also with sufficient gifts. But after some time, her husband and his family members started demanding a cash of rupees 2 lakhs as dowry. And since the same was not fulfilled, the OP number 2 was ousted from her matrimonial house. Full stop. Next, this court further finds that the learned court below has dealt with the evidence of the petitioner who deposed himself as DW1 in the learned court below. Full stop. He has admitted the marriage with the OP number 2, but his plea was that the marriage was performed by virtue of a conspiracy between the parents of the petitioner, and he had put his signature on the nikahnama under fear of parents. Full stop. The opposite party has deposed that he works as a mason. Full stop. Next, this court finds from the materials available on the record that the petitioner is not denying his marriage, but is trying to avoid his responsibility as husband of the opposite party number 2. Full stop. His income as a mason is also not in dispute. Full stop. The learned court below has awarded meager amount of rupees 4,000 per month towards maintenance allowance to his wife. Full stop. Even if at the relevant time the wages of the petitioner as a mason is taken into consideration, it would not be less than rupees 400 per day in the year 2018, which has gone on to increase up to rupees 700 per day nowadays. Please stop. In such circumstance, the award of rupees 4,000 per month is not unreasonable. and needs no interference by this court. Full stop. Next, this revision application is thus dismissed. Stop. Client counsel for the petitioner is unable to say as to whether the petitioner is paying the amount to his wife or not. Full stop. If the petitioner is found defaulting in payment for more than 6 months as on date, the learned court below shall realize the entire outstanding amount with interest at the rate of 12% per annum with a cost of litigation of rupees 15,000 from the petitioner, and the same will be paid to the appointed party number 2. Let the impugned judgment be enforced expeditiously. This application stands disposed of.